75 years old man, and your lordship may fix up any date and we can
What
take up this
where in
matter.
that petition?
It's actually a proceeding has been challenged. It's a caretaker's order.
Give it. Yes.
Your lordship may fix up a date, your lordship.
Central administrative now. High Court of Orissa. Publication number 160112044. I will memo for wooden of the it is listed on
They have put tomorrow too.
The surfacing matter. My lord, where we have already carried out the auction but not able to take possession. My lord, matter was to be listed on December 2024. It has not got listed. We've also planned this for you.
You are to argue the matter. Are you to argue the matter? Have you not engaged any counsel? Acha. Why do you not? If you have got the financial problem, we can provide you a lawyer from the High Court Legal Services Authority. Acha. Oh, acha. What is your prayer in the petition? कि आपण करछन ना यूनियन ऑफ इंडिया को स्टेज रे फ्रेश मैटर ना को अच्छा you
Item 6, my lord. And taken out 2 shot. No, last time also directly file the amendment OA, my lord. I have not received the amendment, my lord.
what is it?
Amendment OA, my lord.
What do you want?
Kindly take out 2 shot, my lord. 6.
Which for the other side?
I have called phone, my lord, but no one received.
How you wait till this? And the matter will fail. Okay.
Item 8, my lord.
Yeah.
Item 8, my lord. Kindly take out 2 shot, my lord. So I have taken instruction, my lord.
Which for the other side? It's a phrase and mission.
They have sought a list, my lord. I have taken instruction from the railway, my lord.
You are appearing in the second item.
Yes, my lord.
In the other matters,
Yes. My lord, I am in the first item.
what about the third one, Ajay Kumar one?
Here, my lord.
Right. Individually नाम लिखी देंगे. Grand Council for the Union of India, Central Government Council. खाली अजय कुमार होती Senior Panel Council.
Ajay, senior panel.
Senior Council for the Union of India. For one time to obtain instruction in the matter, Mishra, the council and councils of the opposite parties present. Because this matter also is a quickly together. WPC number constant. After or type of building.
Let's call this matter we commenting 24
24.
9.
So this is why we yes.
Weekly list, item number 1.
Item 1, my lord. Last occasion, my lordship directed the serving the notice of 567.
567. Yes.
We are already filed the affidavit also, but not in the board. On 31st 10th 2025,
Service affected.
3 personnel died. All personnel died and filed the affidavit. This is the hard copy, my lord. I upload him. You have to meet him.
क्यों ତାଙ୍କୁ ଦେଇକି ମୁଁ ତାଙ୍କ କପି
Who is appearing for appellant? Nobody is there. They have to bring, they have to move application for bringing LR.
it is their responsibility.
Everything is there, that detail is there.
ସେଟା ତ applicant High Peak concern Vrindavan Sethi have inquired that, and the Sarpanch has given that he has died since 40 years ago. And so far the six is concerned Maheshwar Naik, that vice chairman of Konark NAC has given the
And date when five died? Date
2002, but
2002 and six
5 is died 40 years ago.
Huh?
40 years ago.
40 years ago. Died. 30 years ago died.
30 years ago. That is the annexed have annexed that document.
And six
6 died in 2002. NS chairman of NS has given. And 7, that is death certificate there.
when he died?
Charge no there fair. That is the page 7. And page 8.
In the Honorable Supreme Court's order is, since the respondents have not entered appearance before this court, the High Court is requested to issue a fresh notice to them and to secure their presence before deciding the matter afresh. It will be appreciated if the subject matter of controversy is decided by the High Court within 6 weeks. Parties are free to raise their contention because we have not expressed any opinion. Parties have maintained status. So they are not appearing.
CORAM service code. Remember here. He died. I died 40 years back. He died in 2022 and he died.
Whatever the
Complaint is appearing.
5 and 6
1 minute.
page 8.
Who is appearing that?
Your Lordship, I'm appearing for the appellants in this matter.
Yes. Yes, madam. 3 of the respondent whose service was supposed to be affected, they were reported to have been died. You have to bring LRs on record. That's your responsibility.
Yes, Your Lordship. 3 and... Your Lordship, appellant 3 or respondent 5, 6, and 7.
And 7.
Respondent number 5, 6, and 7 are dead. That is the report furnished by the London Council for the state. So you are to take necessary steps in the matter.
Yes, Your Lordship. We'll take a copy of the affidavit and
Anybody is there from on your behalf who can receive the copy of affidavit?
Your Lordship, we'll get it collected from the office of the advocate.
But you see in the order of the Honorable Supreme Court,
Yes, Your Lordship.
there was a direction that the matter is to be adjudicated within 6 weeks. And since long this 6 weeks has already been passed. So
Yes, Your
That stage operating.
hmm,
Stage operating in view of insurance process. So these people are taking correctly now.
so if you don't take steps, then we'll pass the consequential order because you are enjoying that status quo order.
Your Lordship, give us one opportunity. We'll try to furnish the details of the.
Collect the affidavit which has been
Yes,
filed
Your
today,
Yes, Your
indicating the dates of 3 of the respondents. Take appropriate steps. We are granting you 2 weeks time. Otherwise, you'll pass necessary orders. Let me.
Yes, Your Lordship.
The London Council for the
Yeah.
state has filed the compliance affidavit of the inspector in charge of Cook Police Station, wherein it is mentioned that the respondent number 5, Vrindavan Seth, respondent number 6, Maheshwar Naik, and respondent number 7, Prabhakar Naik, are dead. Let a copy of the affidavit be served on the London Council for the petitioners who is appearing through virtual mode and submitted that she will herself receive the copy of the affidavit from the Land and State Council and will take appropriate steps in the matter, and for that purpose 2 weeks time is necessary. Place this matter in the week commencing from 1st of December 2020.
And that earlier affidavit is the wrong affidavit filed dated 25/9/2025. That may be not this. That is the affidavit filed by the inspector in charge.
That we have clarified that it has inadvertently nothing.
Your Lordships, in this matter, the lower court records may be called upon. We would apply for the certified
Madam,
copy.
you take
However,
steps accordingly. You may receive the thing. Once we start up the hearing, then we can, if necessary, we'll call for the record. But do it immediately. We are fixing the date to December 1st. You collect the affidavits today itself from Mr. Naik, the Land Additional Government Advocate, and do the needful. As per the direction of the Honorable Supreme Court, in civil appeal number 8073 of 2020. No.
Item 2.
This is a matter. The Central Bank of India is the appellant against the judgment of the Honorable Single Judge. And in fact, the matter was carried to the Honorable Appeals Court and matter has been remitted back for the hearing of the matter.
What is the order of the Honorable Supreme Court?
X. X. I'm making it very clear from beginning. So a note has been prepared and has been submitted to your Lordship, but that is not adequate because it was given prior to the judgment of the Supreme Court. So
no,
there are some.
This is civil appeal number 2297-2298 of 2021.
Right, sir.
Which was disposed of on 1st July 2021.
Yes.
Please ask your associate to place the order.
Yes.
Or you may place
no, I understand. The division bench of the High Court of Orissa, by its order dated 23rd of February 2021, filed against the judgment of the single judge by the appellant on the ground that it is premature. We find substance in the grievance of the appellant. So bank was the appellant, which has been urged by the Mr. Patwalia, the Land Senior Counsel, that there has been no application of mind by the division bench of the High Court to the merit of the writ appeal. The single judge directed the appellant to consider the case of the respondent for promotion, which was the order on the challenge in appeal. The writ appeal was not premature. Mr. Swansol and counsel appearing on behalf of the respondent on caveat submit that a considerable delay has been taking place and the respondent is retired within a period of 4 months. In the meantime, he has retired now. The ground which has been urged on behalf of the respondent be sufficiently taken note of by requesting the High Court to expeditiously consider the writ appeal upon a remand which become necessary by reason of the fact that the High Court has not dealt with the merit of the challenge in the appeal. Accordingly, in order to facilitate this exercise and without expressing any opinion on the rival contents, we set aside the impending order of the division bench of the High Court dated 23rd of February 2021. The writ appeal being writ appeal number 382 of 2020 restored to file of the division bench upon the writ appeal being mentioned for early listing. We request the division bench to take it up expeditiously in view of the fact that the respondent, as stated by his counsel, is due to retire within 4 months. And the issue pertains to being considered for promotion. In the meantime, 2022 years of the retire. Now the whole question for consideration, before I take your answer to the note and the date charge.
Where is the writ appeals order?
Yes. You have to look to the orders of annexed 5.
Annexed
5 at page 94.
Writ appeal order dated which against you have gone to the
Supreme Court.
Supreme Court.
Something different.
Writ appeal order. Writ appeal. 23/2/2021,
Okay.
writ appeal number 382 of 2020. Present appeal which has been again restored back. May I place that? Order and counsel for the appellant and on counsel for the respondent. By way of this writ appeal, the appellants have challenged the judgment dated 5/2/2020 passed by the Lord Single Judge in WPC number so and so of 2013. The grievance of the petitioner is that the respondent filed WPC number 1563 of 2013, praying therein for quashing of the order dated 8/6/2013 passed by the appellant, and has sought for a direction to opposite parties to give promotion to the promotion to post of scale 5 and scale 6 with consequential service benefit and financial benefit, keeping at par with the batch mates and junior with a direction to comply with the order within the stipulated time. Lord Single Judge allowed the writ application. The extract of the order is as follows. Opposite parties are directed to consider the case of the petitioner for promotion to scale 5 and scale 6 from the date of which the batchmate and the juniors have been given promotion in view of the ratio of the Honorable Appeals Court the decision Gurpal Singh's case and Janagraman's case. The entire exercise be completed within a period of 12 weeks from the date of receipt of the communication of the order. On consideration of the case of this promotion, if the petitioner is found eligible to be promoted from scale 6 to scale 7, from the date of the junior and batchmates were promoted, consequential service benefit as due and admissible be extended to the petitioner within a period of 8 weeks thereafter. However, the appellant have neither considered the case of the petition for promotion to scale 5 and to scale 6 as directed by the court, not taken in decision on such matters. Rather, the appellant have challenged the order of the Lord Single Judge by filing the writ appeal. Since the writ appeal is premature, we dispose of the same with the observation that it is open to the appellants to consider the case of the petition for promotion within a period of 4 weeks from today and pass is in order to that. That is why it's sent back for reconsideration merits. So, this. No, in fact, for my non-friend, I am preparing another note for your.
Why promotion was not given? What is the reason?
I am coming to that. If a proceeding was initiated against the respondent, the petitioner, on the allegation of some there is irregularity in the sanction of loan and advancement, something. And in that proceeding, punishment was awarded. Punishment, that is a major punishment in terms of the regulation that was awarded. Against that, they approached this honorable before this honorable court, and this honorable court directed to reconsider the matter. And that order was passed in 2012 by the. In the meantime, that is the crux. In the meantime, when the penalty was imposed and was in operation, and while the matter of petition he had approached this honorable court before that, a scheme was introduced. That scheme, that a policy, the bank took to have taken the policy jumping of promotion, level jumping promotion. That is called as level jumping. That means somebody is in level 2, he can be given promotion to level 4. But for that purpose, that is a recruitment. But an advertisement was made during that time. In that advertisement, the 60% post was reserved for the in-service candidates. But in pursuant to that advertisement, somebody has to make an application. But there is in that policy, that scheme, that is also admitted fact, there is a provision clause 3.8. That clause 3.8 says that if there is a penalty, if a penalty is imposed against an employee, he cannot take the benefit of this policy. For a period of 2 years. For a period of 2 years. That was only for 2 years. And the period of 2 years expired when the penalty was in operation against him. Then when this honorable court remitted the matter to the bank for the disciplinary authority for reconsideration, the disciplinary authority considered it exonerated. Now the whole question is that there is a regular way of promotion that is there, because he could have also in 2012 That is 2012 to 13. Every year he can have a right also to be considered for promotion. That is, but provided he has to make an application. He has to make an application. But he did not prefer to make an application. Now the Honorable Single Judge remitted, why he again approached this Honorable Court, why I was not considered under that policy, because my juniors and my batchmates, they have already appeared the examination and they have succeeded.
Because he has been exonerated. He has been exonerated.
In the meantime, after the exoneration. Now the Honorable Single Judge, I'll show that that provision in the policy, that referring to 3.9. 3.9 is a provision which is only a pending case. If there is a disciplinary proceeding against an employee is pending, then seal cover procedure, which was in that subject matter of dispute in that both judgment of the Supreme Court, Janki Raman and Guru. That is the only question. Now the Honorable Single Judge, this question was raised specifically before this Honorable Court, that now the problem is this: the persons, those who made application and those who appeared the interview, there is a written test and also there is an interview, and they have been selected, they got the appointment. They got the appointment within that period of 2 years. That policy was in operation. Now those posts are filled up. So now the question is, after in 2012, when he was exonerated, now he came up with an application that I should get it instead of the channel of promotion which is open for him to be considered. That is the subject. But I am proposing to your lordships, I have prepared a note, but I could not able to type it for your lordships. I have prepared the note with a very shortcut note with note of submission. I have also informed my learned friend, also keep it to any other date so that it can be, I can finish it within 20-30 minutes.
Mr. Rotho is appearing.
He appeared private petition, read petitioner. Sole response.
So you tell us a date so that on conference we can. Mr. Rotho, what do you say?
24 November, okay? I am okay on that.
Okay. Mr. Buddhadev Rao and senior advocate appearing appellant submits that a date chart.
With a date chart with a note of submission.
A date chart and written note of submission is required to be prepared for final adjudication of the case, and he may be given 1 week more time for such purpose. Mr. Rotho, senior advocate appearing for the respondent, has no objection to be same on consent of this matter on 24th of November 2020.
That's obliged.
Item 3.
May I please my voice? In the grievance of the petitioners, it is review application that the lead application was disposed of without giving an opportunity of hearing to the petitioners. Contesting opposite parties before the learned trial.
Let us see the WPC number.
WPC number.
You want the review of the order dated 37/2025.
This was disposed of without hearing us. We are the contesting opposite parties before the learned tribunal.
No, your means the BSNL.
Because the petitioners are seeking regularization.
No, what we have done. Also challenging the order dated.
Well, what's
this application approved the tribunal regularized also from to claim.
What is this delay control? See, we have not decided the case on merits. We have condoned the delay only. Why should we ask? What is the question of review? Earlier, while admitting the original application, delay was condoned. That is the notice of the tribunal, and finally, the tribunal say that it is bar by limitation. We said that you have already condoned here on merits. That's all.
But my response submission will be that application.
How are you aggrieved, sir, on merit? If you would have decided the case, then you would have been aggrieved. It is only matter of condonation of delay. Let the matter be heard on merits. Go and participate. Who stops you?
That is the order.
What is the review about it?
My limited grievance is Your Lordship has recorded the consent of the Learned Council appearing for the Union of India. Union of India was, although a party, he has not contested the proceeding. They have not filed any counter.
How does it make difference to
You
you?
see, what we have ordered, observed, that we are of the view that once the delay was condoned by a speaking order by the tribunal, which has not been challenged by the opposite party, dismissing the original application on the ground of delay and laches is not sustainable. Therefore, we feel that it would be appropriate to set aside and the matter is to be remitted back.
Why have you not challenged that order?
Yes, yes, your Lordship may kindly hear with. Your Lordship has referred to the order dated 20th of January 2022, which was pointed out to your Lordship, saying once the delay has been condoned, then the learned tribunal should have decided on merit.
Right.
My resolution submission is that MA was filed not for condonation of delay. That application was filed along with the original application to prohibit the BSNL not to retrace that. And the learning tribunal, while considering this application,
Mr.
just
Barik, it shows that the BSNL has no case on merits. That is why these methods are being adopted.
your Lordship may
We
kindly
have given you opportunity that on merit it will be hard, and you are challenging a delay condonation matter.
Well, I simply pray, my lord, your Lordship may say that the learned tribunal should decide it afresh, as well as delay as well as in merit. That is my limited view.
So delay once condone, why should the
That is exactly what I am saying, my lord. Your Lordship may kindly see the order dated 28th of January 2022.
where is that?
That was an application that is at page 159 in the original date application.
Relevant is page 161. Last paragraph.
This application was filed. This MA for an interim measure have prayed for a direction to the respondents not to disengage them if not already been disengaged in the meantime. So while considering that application,
But
the learned tribunal
it says that the matter of regularization delay is condoned.
So that is there or no?
that just one sentence there. So my resolution submission is assuming that my lord the delay has been condoned.
So assuming kono to delay to condone
My
ki
lord,
lekha hai
even if
assuming
the
kono.
delay has been condoned,
And you have
Again condone the
you
delay.
have not the order. जो order रे delay challenge हला आपन को सुनी कि नहीं आपण सेटा को चैलेंज करेनी तेणु आमे लेखिलु जदि डिले condonation करिकिन आपण एडमिट कले ताले पुनी डिले condonation ने delay count
You should have challenged that order. You allowed it to be attained finality. Then what to do?
Your Lordship is right to observe that. My resolution submission is that where your Lordship is because he has challenged the impugned order passed by the learned tribunal on both on merit as well as in delay. So while interfering, your Lordship under Article 226, if your Lordship finds that yes, the learned tribunal is wrongly condoned the delay, then your Lordship can
Without there being any challenge. Without there being any challenge by you. In his petition, we will give relief against him.
My lord, because the matter is before your Lordships.
No.
Your Lordship kindly see the.
Okay, it's
Don't be so technical now. Go and argue.
This review petition has been filed by the petitioners. To review recall the order dated 37/2025 passed in WPC number 16688 of 2025. It appears that when the said petition was taken out on 37/2025, which was filed by the respondent challenging the order dated 17/2025 of the Land and Central Administrative Tribunal, Cuttack Bench, Cuttack in OA number 260 00122 of 2020. We pass the following order. The operative part of which is quoted here in yellow. We have carefully this one. The Mr. Barik Land Council appearing for the review petitioner doesn't dispute that when the delay was condoned, carry that order.
159 minutes. Page 159.
159.
Yes, my lord. Page 159.
When the delay was condoned by the London Tribunal
In MA number
260 of the 00117 of 2021, the present appellant, the present petitioners have not challenged that order. In view of such a state of affair, the contention of the Land Council for the petitioner that this court should have also given opportunity to the respondent, to the petitioners, to have their say on the ground of challenging matter on the ground of delay is not sustainable, as the petitioners have not challenged the same. Therefore, we find nothing to be interfered in the order dated 37/2025. Moreover, in view of the limited scope in the nature of the petitions as held in the case of so and so, we make him more inclined to answer according to the petition.
My limited response that we shall be noticed before disposal of the case. We are not
decision minute.
ନାଇଁ ଅଛି ମଳା ଦାସ ଶୁଣୁଛି
ନାଇଁ ନାଇଁ ମୁଁ ଏଇଟା ଗୋଟେ ନୂଆ ଡିସିସନ ଆଣିଛି 2022 ଲାଇଫ୍
ଠିକ ଅଛି ଆପଣଙ୍କର ଇଏ ପାୱାର ଫାଇଲ କରୁନାହାନ୍ତି
ମୁଁ ସାର୍ ସାଙ୍ଗେ ସାଙ୍ଗେ ଦଉଛି
ନେକ୍ସଟ
Item 4.
कब लगे
in this writ application, I have challenged the late husband of the petitioner was working as a pointsman under railway, being posted to Bahanagar railway station. Charge was framed against him on various grounds.
Which order you are challenging?
Annex 7 is the order at page 87.
The first writ petition.
First writ petition. Second one is connected.
We'll go one by one. The first one is just an order. Why he has filed that original application, Swarnalata Panigrahi?
First writ application, first way was filed challenging the order passed in the disciplinary proceeding. He was the husband of the petitioner, was removed from service.
He challenged that order.
She challenged that order. And the second one was seeking appointment or
husband was dead or what?
Husband is dead.
Okay.
And
the second one is
for compassionate treatment.
Okay. So the first one, what happened?
First one, my lord, that the way is being allowed, my lord. Your lordship will, on a very technical ground, by misinterpreting the order removing him from service. The lordship permits, I will place the relevant portions of the order. It starts from paragraph 5 at page 101. May I please?
Yes.
We find that the applicant has placed much emphasis to decide as to whether the punishment notice number GM 57 staff D&A such and such can be said to be an express order of punishment, or this is a notice which should have been followed by a specific order of punishment. In this regard, we have minutely perused the punishment notice number such and such, the relevant portion of which is quoted below. Hence, it is decided to remove you from railway service with effect from 21/2017 by sanctioning of 2/3 pensionary benefits as per extant rule as a measure of punishment. Please acknowledge receipt of this notice. You are at liberty to prefer revision petition, if any, before this appellate authority in polite language and within 45 days from the date of receipt of this order. This is the, my lord, dismissal order from service. It is well settled principle that to decide implies to make up one's mind to do or not to do something. It is a situation to choose something, especially after thinking carefully about several possibilities. In the order, it is stated that it is decided. This phrase is in present perfect tense, which indicates that the person has made the decision but has not necessarily acted on it. Therefore, an examination of the word used in the punishment notice number such and such implies that husband of the applicant was not imposed with the punishment as decided therein. This is more fortified by the subsequent language used in the order that the husband of the applicant to acknowledge the receipt of the notice and to prefer revision before the appellate authority against the proposed action. There can be no gainsaying that as per the rules, the order of the DA must be self-sustaining one and explicit order with no ambiguity insofar as imposition of punishment is concerned. We must hasten to clarify that the government doesn't have a carrot and blanche to take any decision it chooses to. It cannot take a capricious, arbitrary, or prejudiced decision. We are reminded by celebrated decision titled Mohinder Singh Gill versus Chief Election Commission. The respondents have stated that have considered the appeal preferred by the husband of the applicant and the same was rejected and communicated by letter dated such and such. But fact remains that the husband of the applicant was restrained from duty on the strength of punishment notice number such and expired on such and such date. No evidence has been filed by the respondents regarding service of such order dated 19/1/2017.
That's the basic. That is the basic.
My lord, no evidence has been filed by the respondent regarding service of such order dated 19/1/2017. However, on examination of the said order dated 1/3/2017 and the order dated such and such, we find the request was rejected without considering aspects noted above, albeit rule requires that the authorities concerned considering the appeal or revision have to take into consideration all aspects of the matter with due application of mind. Thus, the said order obviously can be said to be an order without complying with rules and without application of mind by the appellate regional authority. In this regard, our mind is reminiscent to the legal maxim sub lato fundamento cadit opus, meaning thereby in case a foundation is removed, the superstructure falls. Further, code contra legum fit, pro infecto habitur, meaning thereby what is done contrary to law is considered not done is a well settled position of law. In view of the fact law discussed above, the net result is that the impugned order dated such and the order dated such and such are not sustainable in the eye of law. Although number of collateral issues had been raised by the Learned Council for the appellant, we deem it appropriate not to opine on the same in view of the conclusion reached above. Since government servant, that is husband of the applicant, is no more based on the punishment notice number such and such dated such and such, his family members cannot be deprived of the death cum retirement benefit, and in such circumstances, remanding the matter would not meet the ends of justice. Hence, the respondents are hereby directed to release all the benefits to the applicant as if her husband expired while in service within a period of 90 days from the date of receipt of the copy.
You now show us that you have served.
Your Lordship, kindly Lordship, kindly allow me to place the order. The order of dismissal from service.
No. Have you served it or not?
It was duly served, my lord.
You have not.
Thereafter, the appeal was filed by him.
If you have served and the finding is you have not produced any document.
Yes, my lord.
Then go and file a review and say that these are the document.
My humble submission is these
are finding of facts. These are finding of fact that you are failed to supply the necessary document, furnish necessary document that you have served.
My lord, after
the finding.
My lord, after passing of the order in the dismissal proceeding, it was duly communicated to the ex-employee. Thereafter, he preferred appeal against that order. And the appellate court, ultimately the order of the appellate court, while was pending, he died. It was communicated to them. Thereafter, the wife, present petitioner, my lord, filed an OA before the Central Administrative Tribunal to allow him to file revision before the appropriate authority. That permission was granted by the Central Tribunal. Thereafter, the revision was filed. the revisional court upheld the order of the disciplinary authority as well as the appellate authority. Thereafter, the present the OA was filed. Now, my humble submission is, my lord, the London Tribunal solely on the basis that the order of punishment is not an order, it is a notice, has held that the order should go, and since the foundation goes, the superstructure goes. That is the view taken by the Central Admin Tribunal. I will take your lordship.
Yes, you have already entered appearance. You accept the notice and file your counter.
I am not accepting.
Hmm?
No, my lord, I am not accepting.
Why have you then entered?
That-
You have entered appearance by filing Vakalatnama.
Yes, sir.
But how do you say that you have not entered?
My lord, I'm not accepting that the punishment order was served upon.
But he says that punishment order was served upon
That
you.
is
You
to be
challenge that in
adjudicated
appeal
to-
law.
Yes.
These things has to
Have
be
you received the copy of the writ petition?
Yes, madam, I have served. I have served.
You
My
are,
lord, I'm coming to that.
file your counter affidavit so that it can be hard.
I'm coming to that one.
Issue notice on the question of admission indicating that the matter shall be disposed of at the stage of admission. Since the Learning Council, Mr. Swai has already entered appearance for the opposite party and received the copy of the petition. Matter being listed. How much time you want to file counter affidavit?
Okay, that-
Matters listed in the week commencing from 8th of December 2025. In the meantime, counter affidavit if any is served on the Land Council.
You prepare a lease update and show us. After service, he has challenged of those orders.
Same,
Yes,
same matter.
If you can demonstrate, then you have a
Other matter.
Actually, my lord, that punishment order never served.
let him. He says that you have challenged that order.
That's the reason I, my lord, for
If it's not
stay
served,
for
how
the
will we
proceeding.
challenge it?
Punishment
My lord, they have initiated a content proceeding.
Okay.
My lord.
You have to file the lease update, sir.
Yes, I will file.
Yes, that will come on 8th December 20.
There is an I, my lord, for stay of
You have
order.
filed a content petition.
Yes, my lord, that is there.
The what is that content petition
Content
number?
coordinate proceeding number 55 of 2025.
Where have you given that?
I have not given that, my lord.
Then
I have filed an application to stay of further proceeding. That is
stay
there.
of further proceeding.
Stay of, my lord, stay of order.
Proceeding 9th of
My lord, stay of impugned order I have filed.
Huh?
Again. Lordship,
You give find that
order to stay of the order.
with a memo you give that
Just now I am giving. I am
the
giving.
like on the IN number so and so. Mr. Mishra,
I am giving a memo.
Land Council,
Actually, my lord, my lord,
Senior
no,
Panel
no,
Council for Union of India, files the submits that in the meantime, on non-compliance of the order dated so and so, the opposite party have filed a content petition hearing number so and so.
CP number 25.
And since this matter is posted to 8th of December 2025 for final adjudication, that shall be the learning tribunal be asked not to proceed with the said content petition.
When is the date in the content
Wait,
proceeding?
my lord, I don't have the exact information, but they have filed. We have filed so far.
In the in view of the Learning Council for the opposite party has also not disputed about the filing of the content petition in the Central Administrative Tribunal. The Learning Tribunal shall not proceed with the content petition till the next date. Yes.
Connected matter, my lord, same model.
Okay, that's same one.
Item 5.
Last occasion on my upfront deposit miller and after losses intervention, the matter was sent for mediation miller and subsequently the mediation was failed miller. Though the bank has not interested to accept my this application.
Who is appearing for the man? You are there.
Come to page 5, para 11. Page 5, para 11. May I place my note?
Yes.
That they have been submitted that the petitioner that he well aware of the settled position of law. He only seeks intervention of this honorable court towards protection of his residential house by clearing the entire outstanding as stand against it within 2 installments.
No, what happened? We have sent it for a particular purpose.
Yes, that paid my lord, because we have sufficient. Just paid
How much outstanding dues are there?
outstanding my lord, by 22, it is 15 lakhs 88,000 to.
Oh, how much he agreed to pay?
My lord, he is only asking for 9 lakhs.
This is not maintainable, and council, we refer the matter to mediation because you have alternative remedy with you. So approach the DRT. So if you will not pay the dues of the, there is no question of.
The bank doesn't agree. What can we do?
Fully aware about the jurisdiction, Miller. Submission is, as per the 34 notice, it was 15 lakhs outstanding. I had deposited 5 lakhs. Now is the 10 lakhs, Miller. I am ready to deposit 10 lakhs, Miller, by waiving the interest, Miller. Bank, without considering the sale,
You have to give, bank has to take. Who are we? You have to convince them.
That is the purpose when we made such a submission. That is the reason why we sent it for mediation. But there is not possible. So what can we?
No, Miller. The bank kindly see their conduct, Miller. I am interested to pay, Miller. I deposited 5 lakhs. Now it is Miller 10 lakhs. Only I am seeking, Miller.
See, in a writ jurisdiction, we are not here to decide the conduct of parties.
Aware about that, Miller.
This writ petition has been filed.
So the bank will take a decision on that case.
No question of giving that. Challenging such and such. When the matter was taken off on 8/8/2025, we passed the following order. Now the mediation report has come, wherein it has been mentioned that the mediation became unsuccessful. The inverted comma. The Land Council for the petitioner submits that when 13/4 notice was issued, the outstanding dues was as reflected therein was 15 lakhs and all, out of which the petitioner paid a sum of rupees 5 lakhs, and the petitioner is now ready to pay the balance of balance amount to the bank and stop. Since when such a submission was made and we referred the matter to the mediation, and the bank, the mediation could not be successful. That is why we are of the view that since in view of the decision, so and so alternative efficacious remedy is available with the petitioner, is at liberty to approach him. It is made clear that we have not expressed any opinion on the merits of the case. Yes, Mr. Das is present for the State Bank of India. Yes. Yes.
May I make only small prayer, Miller? My OTS application is still pending before the bank.
It is open to the petitioner to approach the bank for amicable settlement. Yes, next.
Item 6.
Kindly taken 2 weeks after my last time also direct to file the amendment of petition and the regender, my lord. I have not received, my lord.
Oh, you next one, the original application, but
yes,
that was amended subsequently, and you are supposed to file the amended
where with the regender,
and also the regender affidavit, right?
Yes, sir.
So, why are you not filing it? Must be available with you.
No, I have a contact with the office, my lord. They will supply next 2 weeks after, my lord.
Mr. Gopal Krishna Nayak and Central Government Council 6 weeks for the time to file the amended way. So, the regender affidavit filed by the opposite party before the and central administrative tribunal. Put up this matter in the week commencing. एक तारीख रखो जो
8 May.
अच्छा, please this matter on 8th of December 2025. Yes.
Yeah, I'm Paparesh.
This matter. What is your good name, Land Counsel?
Prithviranjan Behra.
Mr. J.R. Behra, Land Counsel for the opposite parties present. Yes.
Item 7.
Yeah.
That's it. After the last order, affidavit has been filed by the petitioner as to whether any proceeding pending before DRT or any appropriate quorum, and what steps have been taken by the petitioner after 25/7/2016 against the bank regarding the issuance of sale certificate and also the delivery.
Yeah, just a minute. Yeah, so that an affidavit to that effect is filed specifically indicating what steps have been taken by the petitioner after 25/7/2016 against the bank for not performing its part and adopting the sale certificate in favor of the petition and not handing over the possession of the property in place. Where is that affidavit? Asha? Just a minute. Look on this writ petition has been filed by the petitioners inter alia with a prayer for a direction to the opposite parties number 1 and 2 for issuance of sale certificate in favor of the petitioner. It is the case of the petitioner that they are the bona fide e-auction purchasers of the property and which was conducted by the opposite party bank under the provisions of Surface Act on 25/7/2016, and the petitioners participated and the bid amount of rupees 37,40,000 was accepted by the respondent bank, and they have also duly deposited the entire bid amount with the respondent bank within the stipulated period as per the terms and condition of the auction sale. And despite the full payment of the sale consideration, the respondent bank has neither issued the sale certificate in favor of the petitioner or handed over the physical possession of the property to the petitioner. It is the further case of the petitioner that a number of occasions the petitioners approached the opposite party bank, and however, no fruitful result has come out. That is the reason why they have approached this court. And the matter was taken up on 22/10/2025, and we made a query to the Land Council for the petitioner as to whether the petitioners approached this court earlier or availed any other forum to ventilate their grievances, as nothing in that respect has been mentioned in the writ petition. The Land Council answered in negative, and that is the reason why we asked the Land Council for the petition to file an affidavit to that effect, specifically indicating as to what steps have been taken by the petitioners after 25/7/2016 against the bank for not performing its part and not issuing the sale certificate in favor of the petitioners and not handing over the possession of the properties in question to the petitioners. The petitioners have filed an affidavit wherein paragraph number 789K wherein it is stated as follows. 7, 8, 9, and 10. Stop. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. What they will do, this collector, deputy commissioner, and what they will do in this matter. Your grievance is against the bank. Bank is not giving you the sales certificate. The collector would do. Nobody has approached section 14 application.
Bank will approach
collector.
History question because now the OP number 5, who is the original
OP5 will issue notice. Bank will issue notice 1, 2, and 5. Why have you added this collector and deputy commissioner of police as parties? What is their role? Because the 14 application has not been filed. The bank is supposed to file that application, and that has not been done. So, if it is your stand, now issuing notice to these 3 only. Level issue notice on this one also to opposite parties number 1, 2, and 5. Requisites for issuance of notice by speed post with proof of delivery shall be filed within a week. The matter be placed on such answers. Yes, next.
Item 9.
Yes, Mr. Bhoi.
May I please? My lords, order of the DRAT Kolkata at Annexure 1 is under challenge. My lords, the same order has been challenged in the second bit writ petition. The bank has challenged that order, my lords. I am the auction purchase.
No one is satisfied with the order of the DRAT.
My lords.
No one is satisfied with the order of the DRAT. You are the borrower.
No, he's the auction purchaser.
Auction purchaser.
My lord, I am for the bank matter.
Bank.
Today we have filed the result.
This counter affidavit has already been filed.
Yes, ma'am. I have filed the counter in one case. On the first case, I am today filing my locker.
You are for bank.
I am for the
Borrower.
Guarantor.
No, just a minute. In the second case, which has been filed by Tuna Sahoo,
Yes.
so they are counter affidavit has been filed by Mr. Bhoi has filed that.
No.
OP number 1. Mr. Bhoi, you are appearing in that case.
My lords.
Okay.
OP2.
OP2, acha, all right. OP1, who is OP1? No, ki mane
Borrower, my lords.
Acha.
Guarantor.
Acha, Debendranath Das hochi guarantor. Apana hochenti borrower.
Auction purchaser.
Auction purchaser. Right. So, who has filed that counter affidavit?
I have filed.
You have filed. You have not filed that counter.
No, my lord. My lords, my writ petition in the first writ petition may be treated as a counter affidavit.
So you have challenged you don't want to.
My lord.
All right, let's go. WPC number second. Just a minute.
File the result to
Just WPC number second order 23693 of 2025. It appears that the opposite party number 1, Debendranath Das, who was the guarantor, na?
That's guarantor.
Guarantor has already filed the counter affidavit, and copy has been served on the Land Council for the petitioner. Today, the Land Council for the petitioner has filed the rejoinder affidavit in court, copy of which has been given to the Land Council for the opposite party number 1 as well as opposite party number 2. Stop. The rejoinder affidavit is taken on record. Mr. Opres Bhoi, Land Council, acting for the opposite party number 2, submits that he doesn't want to file any counter affidavit as he has challenged the very same order which the bank is challenging in the connected writ petition, that is WPC number 28708 of 2025. Stop. This matter, in this matter, first matter, notice has not been issued.
No, my lord.
Acha. Lekhondu.
My lord, the caveator has entered and notice has been, I have given the
just
copy.
Since the caveator, who is the caveator?
My lord, that OP1 in the second.
Yes, but bank has
Guarantor.
not entered appearance there.
Yes, my lord, we have entered appearance.
You have already entered in the first matter.
That is correct. We have
Acha.
got the copy of the
Copy also has been sought.
All right. It appears that in the party number 2, Devendranath Das, the guarantor, have already entered appearance. Their name may be reflected in the cause list henceforth. And stop. Mr. Apres Goyal and counsel submits that he has already served the copy of the writ petition on the land council for the opposite parties. Are you interested to file any objection to that?
That's not required.
Are you interested to file any objection in the first one?
we have taken some time.
No. Same order it is. The land council for the opposite parties that they do not intend to file any counter affidavit in the first in the writ petition, as they have taken their stand in the connected writ petition, that is WPC number 239693 of 2025. Since the pleadings are complete, the matter be listed on Quebec to it a final disposal by Nova.
That's on 1st December.
1st December. 1st December 2025 for final disposal. Yes.
My lord, interim order.
In which case interim order is there?
Second.
Acha, second interim order dated. Acha, interim order dated 8/9/2025.
Yes,
passed in IN number so and so shall continue till next date. All right.
Item 10.
Yes. I am appearing for opposite party 3 to 5 for the Kendriya Vidyalaya Sangathan. Copy of writ petition not yet served on me. I filed an Uklan on 14/10/25. My name also reflects in the cause list.
कहाँ पाई अपना अपील कुर्चुंदी?
OP number 3 to 5 Kendriya Vidyalaya Sangathan.
केंद्रीय विद्यालय संगठन.
OP 3 to 5. Let him serve. Let her serve copy of the writ petition on me. I will take instruction and file counter.
आपनकर ना cause list
Hrishikesh Tripathi. अच्छी मैडम. Hrishikesh Tripathi.
No, that is there. So
My lord, I have already filed on 14/10.
No, it's all right. So you receive the
No, not
the
for.
voucher.
My yes, ma'am.
You receive it and file your
My lord, objection on 8th December.
No, it notice any the notice कर दो जो formalities टा.
My.
Look, this writ petition has been filed by the petitioner Sandhyarani Mahanti, challenging the order dated so and so of the Land Central Administrative Tribunal. The Mr. Hrishikesh Tripathi, Land Council, has already entered appearance for opposite party number 3 to 5. And the you are Mr.
Gopinath Sethi.
Mr. Gopinath Sethi, you are Senior Panel Counsel, is appearing for opposite party number 1 and 2. The copies of the writ petition has already been served on the Land Council for the opposite parties number 1 and 2. So also the Land Council for the opposite parties number 3 to 5. To seek some time to file the counter affidavit for the notice. After they have already entered appearance. केबे रखियो अकाउंट अपन काउंटर फाइल करियो
We can some 8th December.
This matter on 8th of December 2025. Counter affidavit, if any, be filed by the respondents. In the meantime, serving copy on the land council for the petition. Yes.
Similar matters are pending. Similar cause of action, similar matter are pending and taken together. And
The matter admission
No matter. That copy also not yet served. We have not also. We have not.
We are bringing this matter on Wednesday. This is charity matter କରୁଛନ୍ତି ସେଦିନ ଆପଣ ଯାହା ଷ୍ଟେପ୍ ନେବେ ୟା ସାଙ୍ଗରେ 8 ତାରିଖ ଦିନ ଆସିବ
Let him.
ସେଇ 8 ତାରିଖ ଆସିଲେ ସେ ସେଇଦିନ ଏଇଟା ହଉଛି ଡେ ଆଫ୍ଟର ଟୁମୋର ଆସିଲେ ଆପଣ କପି ଦେଇଦେବେ ସେଗୁଡାକ ଜଷ୍ଟ ଲିଷ୍ଟ କରେଇଦିଏ ତାର ମେମୋ ଫର୍ମ ଦେଇଛନ୍ତି ନା କେମିତି ଦେଇଛନ୍ତି ଗୋଟେ କାମ କରନ୍ତୁ ଆପଣ ମେମୋ ଫର୍ମରେ ଦେଇଦିଅନ୍ତୁ 4ଟା ଆଗ ହେଲା that would be better ସେଟା ଦେଇଦିଅନ୍ତୁ ସେ 4ଟା ଆଗ ମେମୋ କେସ୍
just now I was by taking them.
Notice has been attached. Okay, we'll just 11 onwards we'll take after little while. We are taking of this second list of 2 o'clock right now. Some matters we are taking, then we'll go there.
Weekly daily second half. Item number 1.
Except for life of 37362I and 376D. Conviction for life under 376(2)(I) and 376(D).
Life imprisonment. Right, hard admission statute number. Admit. Yes, next.
Admit.
Item 2.
Usual call for the trial court report. So on so what is this criminal appeal defect wanted to be removed from with the counsel, Mr. Tukuna Mishra. What is this matter, Mr. देख लीजिए तो जो ये भी इसका चलती आइटम नंबर इधर हाँ ठीक हाँ 302 life imprisonment.
Life.
What are the defects that has been pointed out? Some people so on so properly having limitation. अच्छा limitation भी अच्छी.
26.3 8 9 13/4/18 date of judgment filing हो 8/9/25
क्रिमिनल अपील
आया
इतने दिन नहीं किया मैंने फाइल करा नहीं जेल क्रिमिनल अपील फाइल करना. Okay, we are adjourning this matter, so we are calling for a report from that London session judge. That's why, because the judgment is dated 23 April 2018. Maybe that he might have filed any jail criminal appeal in the meantime, and that number may be available. Office to verify kuru or shared would read. So number matter is on non appears for the appellant. The staff reporter has pointed out that there is delay of 2635 days in filing this criminal appeal. The interim judgment is dated 23rd April 2018. Let a report be called for from the London Session Judge Kalahandi Bhavani Patna as to whether the appellant has filed any jail criminal appeal challenging the impugned judgment and order of conviction or not. Stop. The Land Council for the state shall also obtain necessary instruction to the Superintendent of Circle Jail Koraput in this respect. And the office shall verify whether against the impugned judgment any appeal oblique, criminal appeal oblique, jail criminal appeal has been filed earlier or not. So we are granting you 1 week time.
Okay.
So put up this matter on 24th of November 2025. The file be placed before the land register on the judicial. We shall communicate the order to the land prior by you, and the communication, the response shall be made by such and such date. अब कर देवे 20 तारीख भीतर जंती ऐसी पहुंची हो. Yes. A free copy of the order be handed over to the Land Council for the state. Yes, next.
Item 3.
By the order dated the instructions of further instruction are sought for. The only one instruction is given for appellant 1. Other I need some more time, 1 week time.
So how many appellants are there?
Because there are 5 appellants. The update instruction he was released on 1/1/2010. But so far other appellants are concerned, we may allow some time to take things.
You see the appellant, your instruction which you have been received from the Superintendent Special Jail Bhanjanagar is only with respect to that appellant number 1, Mani Sethi.
Yes.
But he has been released on bail. But whether he is now alive or not, that
further report I may say that.
Also the report of the other persons.
Same thing you are telling.
Only 7 days time.
24/10 to 25 order you have not complied. You simply say that earlier.
24 ଆମେ ଏଇଟା ଅର୍ଡରଟା ପାସ୍ କରୁଛୁ ଆଉ ପୁଣି କଣ ଗୋଟେ
17/10/25 ରେ order pass କରାଯାଇଛି. You have to comply 24/10.
7 days time.
The Land Council for the state is seeking some more time, not only to comply the order dated 24/10. 24/10. Obtain instruction regarding the well-being of all the 5 appellants. Put up this matter. So we are listing it on 24. Put up this matter on 24. Really, Dr. Negi, how seal
Item 4.
So the first story since long, the IE for bail not filed. That is the on 17/10 the appellant was cleared through VC. On 17/2025, the appellant was appeared through VC and confirmed the name of the council.
No, last time on 24/10 we have appointed on Vidut Lata
Mohanty.
And she was supposed to file Vokalat. and application for fee.
So maybe that since we are taking up the matter
But
now.
he has not filed the application. So,
non-appears. On the last date, she was there.
Yes.
Non-appears for the appellant. As for the order dated 24/10/2025, neither any wakalatnama has been filed, nor any application of bail was filed. So the Land Council submitted, took time to file the wakalatnama, also to file the application for bail. But the same has not been done. That will be listed day after tomorrow. Disengage further. Disengage further often. Yes.
Item 5.
5. As per order dated 27/10/2025, the authority concerned have contacted today also. He will come for discussion. I prefer 7 days time to submit the detailed report. How many persons have been flee away from the
absconded.
Absconded from the custody. Ashram.
Open air.
Should
apprehend him.
So for the present appellant
Apart from that, we have also called for a report from the superintendent as to how many convicts we are lost in Biju Patnaik Okunayar Ashram Jamujari have absconded from the ashram till date, to give their names, case number, status of those cases, and steps taken by the state, if any, against the hearing officials, and also to prevent such absconding. This is very clear.
Today is coming for discussion. That's why I prefer 7 days.
The Land Council for the state 6 wanted more time to comply the order dated 27/10/2025. Place this matter on 24th of November 2025.
Public.
Item 6. In place of Lakshmi Narayan Patel to say engage kariyo jao. Another prisoner's petition has been received for engagement of Mr. A. Saurav. अच्छा latest टा कुठं झालं?
Will clear the issue.
Item latest petition. Yes, Saurav का. So he has not filed any wakalatnama.
It was not
Mr.
listed.
Saurav. Huh?
It was not listed.
So you just we are engaging him because his name is there in that prisoner's petition. So ask him to file the wakalatnama collecting this.
Yes, so
Okay.
Or you collect the wakalatnama and
We'll collect and hand it.
that would be better. That is from Sub Assistant Jailer Special Sub Jail Gunaingaon लिखा है ना? हाँ थोड़ा कर दो. लिखो. Two prisoners' petition filed by the same appellant are placed before us for consideration. In the first petition, which is dated so and so, the appellant has prayed for engagement of Mr. Ashwinaran Patel as his advocate, in persons which Mr. Patel has filed wakalatnama. However, another prisoner's petition has been sent by the appellant, which is dated so and so, wherein he has requested to engage Mr. S. Saurav in place of Mr. Ellen Patel. Stop. In view of such prisoner's petition, Mr. S. Saurav is engaged as the counsel for the appellant. The names of other counsel shall not be reflected in the cause list henceforth. Stop. The London Council for the state shall obtain, since it's a jail criminal appeal, the London Council for the state shall obtain the wakalatnama of the appellant to the concerned jail superintendent, so that it can be filed by Mr. A. Saurav. Put up this matter on 24th of November 2025. कोई name of other council लिख लो ना. Yes.
Item 7.
Last occasion, Lordship carried to take instruction about the status of the PW5, who is the sister of the present appellant. So we have sent a letter. I pray for someone.
Right. IA number 127 of 2019. The Land Council for the state seeks some more time to obtain instruction regarding the status of PW5, criminal antecedents, if any, against the petitioner, so also his conduct inside the jail.
That has gone.
Acha. So they don't answer. Criminal antecedent and
Antecedent.
Stop.
Jail
However, he submits that he has received the conduct certificate of the petitioner inside jail, which has been furnished by so-and-so superintendent, and the same is taken on record. List this matter on 24th of November 2025. We're just coming within 2 minutes.
Item 8.
For well, A1 of 45. The position of applicant in custody is more than 6 years now. Its custody since 27/9/2009. Really based on circumstantial evidence. And page 33 of the judgment, paperwork page 35, internal page 33.
Judgment page?
Page 35, page 33. Paperwork page 35, internal page 33.
33.
Man.
So 34.
In the present case, apparently it is seen that there is no eyewitness to the occurrence, and the whole prosecution case rests on circumstantial evidence.
Internal page 33.
Yes, it appears on in the present case.
In the present case, apparently it is seen that there is no eyewitness to the occurrence, and the whole prosecution case rests on circumstantial evidence.
Leave that principle leave. तापर कौन अच्छी है तेरे?
Last scene actual page 34 internal page.
हाँ पढ़ो.
As per the evidence of the prosecution, the accused last seen with the deceased. With the evidence of the witnesses that getting the news of the murder of both the sons, getting the news from the murder of the mother, they both went to the spot, taking a degree from the nearby house, found the dead body of the deceased, and the accused were sitting there.
No, what is the relationship between the accused?
Mother and mother.
Ma.
No. Co-village.
नहीं
appellant और deceased भितर relationship.
Mother son.
No. Mother son. 17 PW 17 PW 20 are two sons of the deceased.
Just a minute. PW 17
and 20.
PW 20
are the sons of the deceased.
Sons of the deceased.
The appellant is the
deceased or not separated?
Deceased or not Viranga Purti. Viranga Purti.
মানে ফুটা না জিওটা?
Lady mother.
Viranga Purti.
মানে
এটা মানে লেডিটা?
মানে
Okay. So the appellant, sole appellant is no way related to the deceased. That you want to say?
Villager.
Oh, villager. It's all right. Okay. So, से कौन हला judgment रे कौन आवा वाला? गोटे उसी last scene.
Man.
Last scene किए देखिए?
Both the sons.
अच्छा, they have stated.
The appellant was sitting there with an axe.
अच्छा, आउ कौन सा कोई नहीं देखा था लोग को.
PW 20 is important.
So that is the only circumstance.
Right.
Are leading to discovery है किसी ने?
Recoverable weapon, but that blood group is matching with the blood spent in the weapon.
Recovery of what?
Recovery of axe.
Axe.
Money.
At the instance of the appellant.
From the house of the money.
From the house of the appellant.
Money.
So the blood stain which was found in that axe.
There is no opinion.
There was no opinion. So ये ला एक के दो कौन?
PW 20 में ये important.
Who point rate?
It seems that as if appeared that is the Ankur Vora brought a tangia from his house and
गोटे होची last scene, गोटे होची tangia box. How कौन अच्छी? कौन तो तब रहा? What are the other circumstances available on that one? Or that these are the only two circumstances? Now you come to the last scene, PW 17.
Well, PW 17.
Yes, what he has stated?
He has stated that we had gone to the market.
Come.
Page
83.
Page 83.
Please come to the.
The informant Singarai Putti is my brother. The deceased Viranga Putti is my mother. I know the accused Ankura Vidwa standing in the dock. Accused Ankura Vidwa killed my mother Viranga Putti 1 year back on the day at 3 to 4 p.m. near the house of the accused. Our ward member Kuru Tudu told me that Ankura Vidwa to Maaku Matris. Then I came there at the evening and saw my mother having sustained bleeding injury in lying dead on a stony road. And also I saw there the accused Ankura Vidwa is sitting near the stony bed holding an axe bow arrow and one knife. Then Kuru to telephone to the police. Police came and apprehended the accused.
So it is not before the
After the
occurrence he was sitting there. Can be
After
said
the-
as
What
last
is
scene.
last scene?
It is not last scene.
Law and Court, please.
Oh, law and court below a different matter. After the occurrence where the dead body was found, you were found there sitting on a stony road bed and holding an axe, and also bow, arrow, and one knife. That is the case. तापर कौन आला? Police asked the accused about
Police asked the accused about the death of my mother, and the accused said that he has killed my mother with the plea that my mother was practicing
this
as
is not admissible.
No. Come to PW 20.
PW 20 go. এগুলা তো এগুলা যে করে এগুলা পেয়েছি ওরা just a minute. DW ହେଇଛି ତାକୁ PW ହବ ବୁଝିଲ? ହଁ note ଲେଖିଲେ correction କରିବ. Yes, come to PW 20.
I am the page 95.
Second paragraph, read. Second person.
The occurrence took place 1 month back. Again says the occurrence took place about 1 year back. One day at about 4 p.m. near the house of the accused, Ankurobidwa. My mother was in the brother's house. Then the accused came there and called my mother Birangputi and gave her handia on the village mandap. The accused had also taken handia. Then the accused Ankurobidwa brought Tangia from his house and then dealt blow by the Tangia to the neck of my mother, causing serious cut and a bleeding injury. Then my mother fell down and died. Then the accused threatened saying to kill by shooting arrow. Then I called the villagers to the spot. Then our sarpach and ward members and others came there. Then I lodged the FIR at the PS. This is the FIR. Then
He is eyewitness.
my cross-examination. Cross-examination or 3 miles. I know Ramesh Marandi Barusahi, whose house is adjacent to the house of the accused Ankurobidwa. My mother was killed near the houses of accused Ankurobidwa and one Ramesh Marandi. The dead body of my mother was lying near the house of Ramesh Marandi. The distance between our village and Controla Hatta is about 10 kilometers. The house of Ramesh Marandi and Controla Hatta is intervened by a small hill. There are big trees around the said hill, small hill. On the alleged date, I, along with my brother Lakshman, were in Controla Hatta, and at about 5 to 5:30, walking together came to our village. The son of my brother, namely Kitti Purti, Pidul3, came to our house and said to my brother Lakshmana Purti, that my mother Birang Purti have been taken Handia Rasi is sitting near the house of Ramesh Marandi and the house of the accused Ankurobidwa. My brother Lakshmana Purti PW70 came and called me to see my mother Birang Purti. While I, along with my brother, was going to see my mother, we saw at a distance of 15 feet the accused Ankurobidwa, having held arrow and bow, his hand was moving, and my mother, having sustained cut bleeding injury on his neck, was lying there. Again says, myself and my brother saw the accused Ankurobidwa dealt a blow by a tangia to my mother. Then we, being afraid, came back to our house. For the distance between my house and the house of the Ramesh Marandi is about 3 kilometers. The distance in between my house and the house of the accused is about 3 kilometers. At about 6 p.m., I, along with my brother Lakshmanapurti, came to the spot in my 2 cycles. Within half an hour, we reached at the spot. First, we went to the house of Ramesh Marandi and brought a DVD from his house, and then we went to the spot. And by that time, police had already arrived at the spot. One ward member and a sarpanch had informed about that to the police.
So you mean to say that that is the reason why, in view of the inconsistent version, he has not been held to be an eyewitness to the assault of the deceased.
And his version is contradictory to PW7.
Own brother. He himself stated that I was at a hospital.
So, Mr. It is not a last scene. It is a
After
the occurrence he was seen near.
Statement of 20 last seen by my friend saying TV Ajiv that is the to the eyewitness.
20 saying in the examination chief he says that he saw, and the cross examination he is told
Two types of thing he has stated. Once he has stated.
Again says that myself, my brother saw the accused Ankura Barua dead blow on the tangia to my mother.
No, if he had seen with that man, Lakshmana, ka sange dekla?
PW17, that's not. Both brothers.
PW17 sange gala. PW17 ନିଜେ ତ ଗୋଟେ post occurrence witness ନା ତେଣୁ ତା ସାଙ୍ଗରେ ଯାଇକି କେମିତି ଇଏ ଦେଖିବ assault ଟା?
He doesn't say, PW17 doesn't say that he is. So, he's a post occurrence. And this man says that we both of us saw.
After all, the London trial court has held that it is a case based on circumstantial evidence.
In page 38, internal page 38, the trial court has also held that the ocular evidence is corroborated the medical evidence. In page 38, para
he has quoted those principle of that circumstantial evidence.
In the instant case, the testimony of eyewitness and other witnesses.
Who did?
Page 38. Internal page 38, running page 40. BIA. In the instant, in the case at hand, the testimony of the eyewitnesses and other witnesses are trustworthy. Their evidence is clearly
eyewitness means not eyewitness to the actual assault. Eyewitnesses to the presence of the accused at the scene of occurrence where the dead body was lying. So in that context, he might have stated so. Otherwise, he himself has.
Trial court was not sure whether eyewitness or
No, no, trial court एठी परा कहले जो page number internal page 33 रे apparently it is seen that there is no eyewitness to the occurrence and the whole prosecution case rests on circumstantial evidence. So if he has said like that, how can he say that that eyewitness he might be referring to this? So what? How many years you are in custody?
Yes.
More than 6 years.
Where is the custody certificate अच्छी ना कौन? किम जान ले? जो ये judgment लगता है क्या? Judgment का कर लो. UTP हिसाब रही छी.
On the date of occurrence was that.
27/9/2019 रही छी. 27/9/2019 ले
6 वर्ष 10 दिन
6 वर्ष रही छी. 6 years. Are the land counsel for the petitioner, land counsel for the state? The land counsel for the petitioner submitted that the petitioner is in judicial custody for more than 6 years. And the London trial court in the impugned judgment has been pleased to hold that it is a case where there are no eyewitnesses to the occurrence and the prosecution case rests on circumstantial evidence. Though the London trial court has relied upon the evidence of PW17 and PW20 and stated that their evidence comes within loss in theory, but it appears from the evidence of PW17 that when he arrived at the scene of occurrence, by that time the deceased was already dead and the appellant was seen at a nearby place holding one axe, bow and arrow and one knife. The land counsel submits that the other witness, that is PW20, posed himself as an eyewitness to the occurrence in the examination in chief. But what has been elicited in the cross-examination indicate that he is not an eyewitness and his version is completely contradictory what has been stated in the examination in chief. Land counsel submits that though one axe has been recovered from the house of the appellant, but no bloodstain was noticed on the same as per the C report. Boston मिलना ना Boston ना group मिलना
Boston, no opinion, remarks are degraded.
अच्छा there is no such finding in the C report to connect the weapon in question with the offense, and therefore there are good chances of success in the appeal, and balance of convenience is in favor of the appellant. He further argued that since it's a criminal appeal, jail criminal appeal of the year 2023, and there is no likelihood of the matter being taken up for early hearing, the bail application may be favorably considered. Land counsel for the state opposed the prayer for bail, placed the evidence of PW 17, PW 28, and PW 17, PW 20, so also the relevant part of the impelled judgment. Considering the submission made by the land counsel for the respective party, absence of any direct evidence, nature of circumstantial evidence available on record, period of detention of the petitioner in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail. Copy of the order be communicated to the jail superintendent, so and so, and copy will be also handed over to the land counsel for the state. Urgency required.
And yes, 183 of continuous stay election.
He has not been granted. Vicky? No, there is no order of stay relation of time. It has already been granted by the order dated 15/9/2025. Yes.
Item 9.
Yes, Anima Kumari Dei. That's one order itla last time.
A deposition for the
ଆପଣ ବି କହିଥିଲେ ନବା ପାଇଁ stock taken. Non appears for the appellant, and land counsel for the state submitted that he has received the deposition copies in his pen drive. Please this matter. Day after tomorrow ରଖୁଛୁ 12 somebody ଜଣେଇ ଦେବେ 12/11/2025. Yes.
Item 10.
Non appears 12/11/2025. Equity ଜଣେଇ ଦେବେ ବ୍ୟବରଙ୍କୁ.
There is a note that his contact numbers are not available in the bar directory. There is a noting that his contact details are not available in the bar directory.
You are the state council.
I'll try to.
Previous panel thile pura AK Bora additional standing council thile hala. So Mr. Pradhan, you are not having the contact number of Mr. Beura with you. Yes.
Item 11.
Yes, madam. You have filed an application for bail and also an application for stay relation of fine. So the appellant has been convicted under section 302.
He's been custody
since
6 years, 11 months.
8/12/2018. And
6 years?
6 years ago. 6 years, 11 months.
Eyewitness?
No eyewitness. It is not 10 would be relevant. It is not an eyewitness. She has seen the appellant assaulting the deceased right before the death.
कौन है जी?
PW10.
अच्छा, just a minute. No eyewitness.
No eyewitness. But PW10 has.
PW10. कौन पहला पढ़ोगे? He has not supported. He has been declared hostile. Whatever he has stated, let us see. The deceased is my daughter-in-law. I know accused CORAM Lohar.
In the video, who is my co-villager.
Okay.
The occurrence took place 3 years ago. On that day, having heard quarrel between the accused and Kuni Lohar, I asked Sukram about the cause of quarrel, but he refused to say anything. Then I went away. I have been examined by the police.
Data कौन है? इसका किस करना है?
You should have. I'll read the cross-examination part.
Cross-examination.
All the prosecution witness. There's a fact.
Which para? Which para?
Para 2. I'll start with the para 2.
It is a fact that.
It is a fact that the Kuni Lohar, who is the deceased, was married to my son Sanjay Lohar, who were having one daughter out of their wedlock. Then my daughter-in-law developed love with the accused and stayed with him in live-in relation. On that day, 8 p.m. night, having heard the sound of beating, I went to the house of Sukaram Munda and found my daughter-in-law sobbing. When I asked Sukaram as to why he is assaulting, my son dragged me out of the house of the accused. The accused hit Kuni Lohar by means of a stick. When the stick got broken, the accused assaulted her by means of an iron pipe. The accused also chased me and my son. We ran away towards village to save our life. When the accused grabbed the neck of my son, my son ran away after getting himself freed from such clutch. On the next day morning, the police called us. We found Kulinar lying dead.
What about the hard sentence in the cross-examination?
That is a fact.
I have not seen the occurrence.
He has not seen the occurrence. He has seen the appellant assaulting the
It could
deceased.
be a last scene kind of.
It's a last scene kind of. Yes, sir. It was in the evening he assaulted the deceased, and in the early morning she was found dead.
Previous night there was a quarrel and all these things
There was a
happened.
quarrel and
Next day this dead body was found.
yes.
So it could be a last scene.
Yes, sir. You should kindly see doctor's evidence, PW8. The manner of the crime. There are 16 injuries on the body. And the opinion, as per Para 2, the death is homicidal. And the weapon of offense was also confronted to the doctor in paragraph 3. And he says,
You are first reading the evidence of PW?
10 years.
10. Then indeed.
Then I will place PW1 and 2. May I please?
Yes.
1.
I'll start with PW1. Paragraph 2 will also. The deceased Kunila was my first wife. The occurrence took place 2 years back on 6th December. On the occurrence date, there was an altercation between the accused and deceased. My mother attempted to subside the matter and my call. She did not interfere, and we both left away from the occurrence place and we went to our new house. The house of the accused situates near our old house.
That night, really.
That yes, sir. Then paragraph 5 will also. The deceased had been staying with the accused 2 to 3 years prior to her death after leaving my house. I have not married to another lady and staying with my daughter. On the occurrence date, I had gone to our old house with my mother. My mother protested the accused not to accuse the deceased in filthy language, and he tried to intervene when the accused was meeting the. It must be beating the deceased. I haven't seen the accused assaulting the deceased by means of a steel pipe. However, I have mentioned in the affair that this is by means of a steel pipe and a bamboo stick by the accused in my presence. There were PW2 years. I'm conscious that the person has become hostile.
But in the paragraph number 9, He has stated PW1 that the deceased and the accused were leading peaceful life. I have never heard any difference between them.
But
the accused was in the habit of leaving the house and returned after 2 to 3 days on different occasions during her stay.
in the
So,
paragraph 9, so he again said the deceased used to quarrel with me many times and she left the home. Paragraph PW2 unit.
PW2.
PW2 unit. This witness has become hostile. I'll place the paragraph 2 and 3 for a moment. The occurrence took place 2 years back on 6th December. In the night about 9 p.m., I came to know that the occurrence when the accused Sukarans was saying Morigala, Morigala. Next day morning, I came to the spot and arrival of the police then informed the matter to the informant. Police examined me and recorded my statement and confirmed. Paragraph 3. The house of the accused situates an audible distance from my house. On the occurrence night, I heard the accused crying, Mari Deligo, Morigola, Kuni Morigola, Mo Ghara Judigala. At that time, I was present in my house. The father of the accused came to my house and requested me to give a phone call for ambulance and informed me that his daughter-in-law was in serious condition. I asked him as to what happened to Kuni. He replied Sukaram had killed Kuni. I told him to inform the matter to the president of the village and come to answer.
Yeah, he has not seen the, however, he has, however, have heard about her death.
Yes.
There is no direct evidences.
Apart from 10 and 1 who saw the accused assaulting the deceased.
Yes.
Almost all the witnesses are declared hostile. They are the co-villagers, probably that is villagers.
No, the fact remains that the witnesses have at least stated that the deceased was staying in your company.
Yes.
And the dead body was found in your house. And so many injuries were there on the person of the deceased. 16 injuries. So how she died? What is your explanation? The dead body was found in your house. Are you disputing about it? So because the IO came there, and when he found the dead body, he also conducted inquest over the dead body.
113 presumption.
So the you are to discharge the burden. I commanded so guard the dead body, examine so and so, visited the spot, prepare the identify so and so. I examined the seizure witness, weapon of offense, conducted the inquest report marked as any 2/5. ठीक है देखिए inquest report में मुस्ताफार food जगह लिखନ୍ତୁ date and hour of inspection of body ହେଲା so and so, parentage ହେଲା so and so, place where the dead body was found. ମୁସ୍ତାଫାର ମୃତ ଶରୀର ତାର ସ୍ୱାମୀ ଘର ସୁକାରାମ ଲୋର ଘରର ପୂର୍ବ ପଟ ଶୋଇବା ଘର ଚଟାଣରେ ମରି ପଡିଥିବା ପାୟାଗଲା.
The house of your house.
Said that the informant is the husband of the deceased and the accused is in relationship with the deceased.
That's right. 2 to 3 years back, she came and she was staying with you. And you are having that live-in relationship ର ମଧ୍ୟ evidence ଅଛି. ବର୍ତ୍ତମାନ ଏଇ ପରିସ୍ଥିତିରେ ଏଇଭଳିଆ ଇଞ୍ଜୁରି ହେଇକିନି ଆପଣଙ୍କର ଘରର ବେଡରୁମରେ ଚଟାଣରେ ସେ ମରିକି ପଡିଥିଲା. So what have you stated in the cross accused statement? ଖାଲି 999 କହିଛନ୍ତି. ତାର ମଲା ଦେହକୁ ଧରି ମୁଁ କାନ୍ଦୁଥିଲି ସେଇଥିପାଇଁ ରକ୍ତ ଲାଗିଛି.
One of the circumstances that the blood stain of the accused was found. To explain that, he has in the 3-monthly statement, he has explained that thing only. He has stated that since I was
Crying.
yes,
holding the dead body.
ମୁଁ ତାର ମଲା ଦେହକୁ ଧରି ମୁଁ କାନ୍ଦୁଥିଲି ସେଥିପାଇଁ ରକ୍ତ ଲାଗିଛି. That is how he has explained the blood stain ganji. That's it. The weapon of offense is two: bamboo stick and steel pipe. A person cannot hold two weapons in one hand.
We are not that. There is no eyewitness. So the question of
PW10 କହୁଛି ସେ ବାଡିଟା ଭାଙ୍ଗିଗଲା ସେଥିପାଇଁ ଆଇରନ୍ ପାଇପ ରେ ସେ ହିଟ୍ କଲେ.
PW10 ର inconsistent ରହୁଛି also. କାରଣ hostile to reach.
Statement of the mother-in-law of the deceased. She was present prior to the occurrence. Exhibit 17 is
Antecedent कौन अच्छी?
not. It was never called. I will get.
You get that conduct
Yes.
as well as the jail conduct.
Yes.
बाकी period तो जना पड़ची 6 years कितने मास?
Yes.
7 months.
The land council for the state seeks for an adjournment to obtain instruction regarding the criminal antecedent, if any, against the appellant. So his conduct in the jail. 24 तारीख को रोकनी put up this matter on 24th of November 2025. Mrs. Bhakti Sudha Sahoo, the London Council for the appellant, is presented at Kirkland. Yes. Okay.
Item 12.
Yes, Mr. Patnaik. अच्छा, 8 of grant for you. IN number 1 is the realization of fine tax allow for you. Kadir achi item number 11 है ना? Yes.
Number 12 Fellowship has called for the custody certificate, conduct, and the criminal antecedent.
तीनटा पड़े अच्छी.
Criminal antecedent as mu conduct custody certificate and this.
Custody certificate जଣା पड़ियो जे judgment रू कारण भी रहुची पूरा तारो. या ना कोन?
Nini Fulsari. Nini alias Fulsari.
Appellant number, accused number 5. এটা কোন 20/12/2015 লেখা ହେଇଛି. আচ্ছা তার মানে ହେଲା ଆପଣଙ୍କର 10 ବର୍ଷ ଉପରେ ରହିଲାଣି.
9 years.
ହଁ. ହଁ ନା ଅଛି 9 years 11 months. Yes, madam, what do you want?
Item 2. On behalf of Ms. Agarwal, to collect the paper book and file the wakalat number.
Item number 2 মানে JCRLA 105. What do you want?
Take for some time, madam. She's on maternity leave, but may provide some time to file the wakalat number.
So Patnaik is also not there. The London Council for the state has produced कौन आनी कौन दी चंदी?
Custody certificate and jail conduct.
Produce the custody certificate, so also the जमा करो. Custody certificate and jail conduct of गोटे के लिखी देबे हला 8 ले चेकर से appear करते हैं.
Total 4 accused persons.
नहीं फास्ट लिखूं कारण which is taken on record. The London Council for the appellant is not present. Put up this matter on such and such date with JCRLA number 105 of 2024. So you have already been entrusted this brief that Madam Ekta Agrawal. So you have not filed any application even for bail. So the JCRL number 105 पे and कौन engage कराई क्या? So it is just as an amicus curiae you have been engaged. There is no need even to file wakalat number, but you can file the
application for bail.
Bail you should file, and because the judgment indicates that this lady Ritikina was in judicial custody. Same date, this 25/12/2015. Hello, लिखी दियो so and so appearing for Mrs. Ekta Agrawal seeks for an adjournment to obtain necessary instruction in the matter and to file wakalat number. Release this matter on such and such date with JCR in the number 80 of 2024. Hello? Yeah.
Item 13.
Question item number 30. By order dated 27/10/2025, Shilosha has called for a fresh report regarding the mental condition of the appellant. Since in the other day,
Why mental health condition was sought for? What is the case?
okay, sir. Since the report said since the accused person is suffering from psychosis NOS, Shilosha has called for a fresh report regarding the nature of the prognosis of the disease. Can I pray for next?
The non appears for the appellant. Learned counsel for the state seeks some more time to obtain the report as per the previous order put of this matter on 24th of November 2025. The first list corporation. Order should have option.
Weekly daily first up for orders. Item number 11.
My lord, who is for the petitioner?
Appearance of petitioner, pass over yes. Mr. Can you say in
It's a objection by so and so each person submitted by. Nine? No, the London Council for the petition is not there. We are just passing it over. Yeah.
Item 12.
Item 12 by not filing the insulin application for pay of Part C, my lord.
Who has filed this application for early hearing?
I am filing the not press, my lords. First, you file A and B not press.
Just a minute.
Yeah.
IF, this is B, and past application is for stay. Both are you not facing. Click on IN number 12784 of 2022. This is an application for stay which has been filed by the Union of India petitioner, by the petitioner, Mr. Ajay Kumar Rai, London Senior Panel Counsel, doesn't want to press this application. Accordingly, the IA is disposed of. Similarly, IA number second IA would achieve 145556 of 24. This is also not pressed. Same. So not press, not press. Yes, now.
Part C, my lords.
Flat is
18617.
Yes.
There is a filing, my lords, the contemplation, CP number 38 of 2022.
No, what is this matter for? WPC? What are you challenging here?
But the order passed, my lords, by the Central Administrative Tribunal.
25/2022.
Yes.
So here pleadings are complete.
No, my lords.
Then
counter not filed. My lords.
Why are you not filing the counter?
Notice is not issued. It is yet to be admitted, my lord.
Oh, acha, just a minute.
So many hearing taken.
Oh, may I draw your attention?
Just a minute, just a minute.
18 years.
What date here? notice ହେଇନି ଆପଣ appear କରିଗଲେ କେମିତି in sumoto? All right. What are you challenging in this writ petition?
My lord, the order I am drawing your attention.
ରୁହନ୍ତୁ ସିଏ କଣ ତାଙ୍କ ପିଟିସନ ତାଙ୍କର
My lord.
ଆପଣଙ୍କ
My lord, the order and past my lord's annexure 1 page 17.
Yes.
My lord,
What was the prayer of the opposite party in the original application? Have you annexed a copy?
Yes, my lord.
Or come to that
Annexure, my lords.
8 number paragraph को आसନ୍ତୁ. Relief shortfall. To pass the order of rejection so and to direct the respondent to take effective steps to restore the service of the applicant in promotional status of so and so with antedate effect. So the learned tribunal, what he has
my lords, allow the way and directed to my lords in the restoration and
page 25 para 8.
My lord. It is well settled law that the public orders publicity made in exercise of the statutory authority cannot be construed in the light of the explanation subsequently given by the officer making the order of what he meant, or the what was in his mind, or what he intended to do. Public order made by public authorities are meant to public effect and are and are intended to effect the acting and conduct of those whom they are addressed and must be construed objectively with reference to the language used in the order itself. My lords, the edition is by 1978 AR 851. In view of the position stated above, imposition of the punishment until he is found fit seem to be contrary to the rules. It is the case of the respondents that as the applicant was not found fit even after expiry of the currency of punishment reduction to lower stage due to pendency of another proceedings. It is decided not to restore the applicant in his earlier position is found to be not legally sustainable in the eye of law as merely because another proceedings is initiated and pending cannot be a ground to find the applicant not fit for restoration of his original position after my lord's expiration of the currency of the punishment. If any other proceedings are pending, discretion is available with the authority to deal the case of the applicant in said proceeding as per rules and law, but merely pendency of another proceedings cannot be a ground to find the applicant not fit for restoration after currency of punishment is over. This tribunal is also in agreement with the contention of the applicant that the imposition of punishment for specific period become meaningless as it amounts to punishment reduction to a lower post for indefinite period until he is found fit. In view of the above, the grounds based on which the applicant has not been restored in his original post after current punishment does not sound appeal to the judicial conscience. Hence, we quash the order rejection under Annexure A by 3 and direct the respondent to take appropriate steps for restoration of the applicant to his original cadre of LSG.
What happened to the subsequent proceeding which you have initiated?
My lords,
this order is in 2016.
My lords, thereafter, my lords, the Annexure 5, page 94, my lords. The second, my lords, the punishment order, the annex, my lords, here.
Second proceeding.
Second proceeding. Running page, my lords, 94. The last para, my lords, 105, my lords. In view of the aforesaid decision, it is hereby ordered that the Sri, my lord, petition, Srikant Chandra Sundar Rai, P. Dhenkanal HO, now under suspension, be removal from service with immediately.
And what will happen to 2016 to 2019?
My lord,
This order you have challenged.
My lord, it is already quashed.
This is also quashed.
Yes. My lord, my submission is, in the CCS rules, there is no such word unfit for promotion.
That's right.
It is amended in 2010. Everything there is revolving around unfit for promotion, unfit for restoration.
Merely because pending. Proceeding is pending. So proceeding was pending then.
No, proceeding it is already it is mentioned in the by honorable cat that if it is any proceeding is pending, it will take its own way.
That's right. Then 2019 the order is passed.
Proceeding is already passed in way number 180/2023 by order dated 16/12/2024. And my lord, I want to draw your attention. The order he has read out, be punished. It is a recommendatory, no imposition of direct punishment. What he has read out, my lord. And that is on that basis, Honorable Cat has given that this is not a punishment, only a recommendatory. He has passed the order of disciplinary authority, appellate authority, and revision authority. Order is in my.
Yes.
My lords, Annexure 2, my lords, page 27.
Page 27.
27. 26, 5, 2016, my lords. This is regarding the representations, my lords, 7/5/2020.
Punishment order.
Yes.
You put in the final line.
So, my lords,
The last page, for a second.
In the circumstances stated above, refrain from passing the order of this answer, the said order is not an order of punishment in the orders of the appellate authority of the answers. As years have passed, as a consequence, the matter is committed back. The appellate authority to reconsider the matter. The entitlement of the appellant.
What happened? The appellate authority has passed any order?
He has again imposed punishment, my lord. And that is under challenge before honorable.
कौन सी नंबर कितने?
OA number, my lord, 388 of 2000.
So that is pending before the Central Administrative Tribunal.
My lord. 388 of 2000.
He said also is not an order of punishment in the eyes of the thing. Because there was no order of punishment before. So therefore, in 2016, they say that the matter is pending. So therefore, will not give effect. It's completely wrong. We are testing the 16 order, which is completely wrong.
You see, this matter has come today only for a
order
on the ground of your stay application. That you say, but if the pleadings are complete, we can take up this matter. Finally, you have already filed your counter affidavit.
No.
You don't want.
I have only filed counter to the one affidavit, my lord.
No, you give written submission, we will conclude there is nothing in this matter.
My lord.
Let them file written submission. You get written submission. No order.
Is there any urgency of any that content petition is pending?
My lord, posted today, my lords. My lords.
Today,
yes,
the dispose of pay all how many opposite parties are there? Sole opposite parties.
My lord, sole.
Okay. Eppozhando notice is showing that date grant sole authority. Issue notice on the question of the writ petition has been filed by the Union of India challenging the order dated so and so passed by the Lunch and Television Tribunal in OA number so and so. These are the grounds taken on issue notice on the question of admission, indicating that in the matter shall be disposed of at the stage of admission. The Mr. Sahoo has already entered appearance for the sole opposite party, and he submits that you intend to file any counter affidavit or any written note of submission, whatever. Submit that you will file a written note of submission. Within a week, you file it. Within a week, giving the copy to the Land Council for the state. Land Council for the Union of India. Matter will be placed. 1 तारीख आने से final disposal पे. Matter will be placed on 1st December 2025 for final hearing. Through interim application number IN number so also has been filed for stay. Say number translator.
Again, 18617 minus I. The CP number 38 of 2020.
এটা কোন execution case number কোন লেখা আছে?
They will CP मतलब contemplation.
CP number 38 CP ঠিক তো নম্বরটা?
Again, contemplation 38 of 2020,
which is pending in the court of before the Land Central Administrative Tribunal and stated to be a contempt petition filed by the opposite party and which is posted today since we are posting this case to December so and so. The Land Tribunal shall not proceed to the said contempt petition till the next date. Yeah. Yes, next IA is for withdrawal. Yes, ma'am. What is your good name, ma'am?
13.
You have got power in this. P. Anubdas, Land Council for the petition is present. Interim application has been filed for withdrawal of the petition. Land Council. Anybody is appearing for the? Yes, sir. Mr. Devaranjan Rai, Land Council for the opposite party number, not sole opposite party.
I'm for the opposite party number 1.
Opposite party number 2 by opposite party number 2 is present. How can
I'm for the opposite party number 1, Swadesh Narayan Das.
Mr. Swadesh Narayan Rotho, Land Council for the opposite party number 1 is present. The prayer made in the interim application is accepted. The petition is disposed of as withdrawn. Yes.
Item 14.
You are for the. I am for the opposite party. Who is for the petitioner?
I'm appearing on behalf of the petitioner. Senior advocate Shri Solimam sir, he is in another court.
Who is? Solimam. Oh, Mr. Sorochan Mahapatra. Yes.
Received the counter which has been filed by the opposite party today. We received
Your file counter. Have you received a copy of the counter? Yes, Milad, I have served. Acha. The Mr. Gopal Agrawal, Land Council for the Senior Advocate, Land Council for the Union of India, ED, Enforcement Directorate is present, submits that he has filed a counter affidavit has been filed by the Union of India, which is taken on record. Copy of the counter affidavit has already been served on the Land Council for the petition. What do you want, madam?
Any short date maybe?
You tell the date.
It be possible this week since the matter she has been evicted from the house and it's a very sensitive issue for her.
No, hear the matter, but Mr. Agrawal, you tell please the date for that. 14th. 14th I will election matter. 17th. On consensus of Osmanchu, list this matter on 17/11/2025. Madam, what is your good name? Mr. Sorochan Mahapatra and Senior Advocate is present. Mr. Mahapatra, we have recorded that the counter affidavit has been filed today. It is accepted and copy has been handed over to you, and we are taking up this matter next Monday. Yes.
Item 15.
Yes, it is your case, Mr.
So as per the order dated 15/11, we have already communicated with PREP some other day about the deposit account.
Why the cost was imposed?
So this out of the similar nature of cases, batch of cases,
Batch of cases, you have selected one.
not selected. Number of cases.
Despite traffic message judgment is looking at you.
So
Still you selected one.
You have not deposited the 10,000 rupees in the High Court bar.
But we have implemented actually next week, so that will be ensured to.
So that it could be increased.
Not
The
loss of
serious
left to stake.
Our सप्ताह round to टंगा deposit करो, not body those amount.
You know the fate of this case. We are waiting for 10,000.
Land Council for the state seeks for an adjournment till next week to produce the receipt showing deposit of rupees 10,000 in the Orissa High Court Advocates Welfare Fund. Put up this matter on 17th November 2025. Password is what? Step number. Yes, item number.
Item 11.
MOPL has been filed for exploration of the lease appeal. The delay has been pointed out. Application was filed within time. But thereafter, the records of in the registry were misplaced somewhere. In the year 2025, it was traced out. Thereafter, it was sent to stamp reporting. So
you certified copy file कर नथिले.
Yes, certified copy files. Point out करचंती.
कौन पूछेंगी?
900 कितने दिन और
technical support
लिखूँ. डिले टा कौन नहीं है कौन?
हाँ नहीं प्रेस पॉट में भी
cost is अपन बाली यात्रा नहीं है. We are told that sometimes cost was imposed on Srikant Naik, the senior advocate. से पहले का cost कहीं दो, but नहीं dinner पे मैं कौन है Manoj Mishra was the counsel.
And you now.
Number 1. So after hearing the land counsel for both the parties and going through the averments taken in the interim application, we are inclined to condone the delay. Accordingly, delay is condoned. IA number 40.
I
40. Now CMAPL उत्तर कौन पाइबे restoration का वो केबे dismiss इतला है.
इधर dismiss इतला 2000
कौन सा
अपने 10/2022 से दिन ये उसी कोर्ट बॉयकॉट करथिला मु जाक करी मु कोर्ट.
अच्छा ऐसे देखिए इसे जो मेन ऑर्डर था देख रीट अपील टा dismiss है.
रीट अपील टा dismiss
on an appeal. Listen to same appeal so it is also allowed. This W रीट appeal is restored to file and matter be placed for admission.
Restore to its original file, whatever.
Restore to file. Okay. Here. CMAPL dispose of. बाकी जतियो रहिला बुधवार दिन आसीबो.
Day after
tomorrow. Because tomorrow is a different page. No. Separate list as you but these all these matters should be included. Mr. Das, what is your matter? अच्छी तो list है.
Matter is pending before the learned districts Bolangir. The lordship also called for that report from the learned districts.
We'll see day after tomorrow.
Yeah.